Okay, we're going to open the meeting up, the zoning hearing board for December 15th. December 15th, 2020. And a couple things I want to mention before we get started. We're not going to go in order tonight. We're going to take the appeals 5, 6, 7, and 8 first and go back to appeal 4 after they're done. We probably got some housekeeping things to clear up. I know, Adam, we had that one appeal last meeting where we were checking on the impervious surface. I believe they came through. Do you want to just bring that up? I think that worked out for that couple. Yeah,
that was originally appeal 20-1885 for Heather and Daryl Geist.
Correct.
Jim Majewski did go out and confirm that they didn't actually need a variance. So that one was withdrawn. And then, as you said, we're gonna try to get the other ones, the Hydrascape, the Schwinds, the Mons construction for Shannon Lopez and Christopher Schoffler, try to get those resolved first and hopefully expeditiously. And then we'll move to 1881, which is the challenge to the overlay ordinance.
All right. Our first appeal will be number 20-1886, Hydrascape Incorporated with Aaron and Karen Cohen. They would please step up, be sworn in, and maybe Adam can enter any kind of exhibits that he may have.
Sure.
Aaron is coming in now.
I'll wait till they get in and then I'll do the exhibit just so they can hear them.
Evening.
All right, so we have the application as Exhibit A1, the site plan is A2, B1, proof of publication, B2, proof of posting, and B3, the notice to the neighbors.
Okay. Are they here? Do they need to be sworn in?
Yes, we're here.
No, you need to be sworn in. Bill, are you here? Swear them in.
Sir, do you me swear testimony?
I'm sorry, you were broken up.
Can you hear me, Tom?
Yes, now I can, but you did break up.
Okay. Yeah. Sir, do you solemnly swear the testimony about to give will be the truth, so help you God?
Yes.
Thank you.
All right. I assume I'm talking to Aaron.
That is correct.
If you can tell us what you're trying to do, explain it to the board.
Oh, we're trying to install a pool. And our contractor, Nate from Hydrascape, is doing all the work. And apparently when they came out and did the survey, I already over my impervious surface. Mm-hmm. And the current pool concrete would put us over another 3 or 4%, I'm assuming. I'm hoping Nate was on here. I'm not sure if he is or isn't.
I don't know. Is Nate here? I don't hear him. All right. Well, if he's not, I saw your application. The board has seen it. You have increased your impervious surface from 21.4 to 24.1 by adding the pool and the deck around it. Is there any? There's no dimensional issues with this, correct, Jim?
That is correct.
Okay, so I see it, but obviously we need some kind of mitigation effort to reduce the impervious surface. You're already over the 18 max. I assume you bought the house like that, or did you put any other structures on there that you didn't get a permit for?
No, everything that is here was from when I purchased the house.
All right.
Which was about 3 years ago.
So what is your plan to mitigate it back to 21.4?
So that's why I was hoping Nate was here. I did talk to him, and he was talking about doing a underground, I'm assuming like a French drain of some sort.
Like a seepage pit or dry well?
Yeah. He would actually lay like a fabric down and then some stone and fabric over top, and then the dirt over top. Everything would be underground. We wouldn't even notice it.
Yeah, we would.
I'm a mechanic, so I don't know anything about construction. So.
Well, we would need something by him and then approved by our engineer to reduce that.
He did tell me that. That's why I was hoping he was here. That he would talk to somebody that who would know exactly how big to make this on, I'm assuming your engineer or board.
He would.
And then I guess they would have to draw new plans up on this, I'm assuming. I'm not sure.
Yes, but if we do approve it based on you're okay with doing the mitigation with that, if it was okay with the rest of the board and no objections by anybody else, and we haven't asked the township yet, it would be based on that for our approval for sure.
Okay.
It sounds like you're okay with that. But Barb, let me ask you: are you participating in this?
No, township's taking no position.
Okay. Jim, did you speak to Nathan as he's talking? This guy Nathan, have you spoke to this contractor?
I did not speak with Nathan. However, I did calculate what a representative size of the seepage bed would be to control the runoff that was added for this project. Representative size.
You're going in and out. Your mic's going in and out. Get closer.
Okay, the representative size would be 2 feet by 4 feet by 25 feet.
Okay, and there's a room on the property to put that in there properly.
Yes.
Does anybody else have any questions for him?
Nope.
No, it sounds like he's willing to make mitigation efforts, and I don't know if maybe we can ask the tech if Nathan's like in a waiting room or something. I don't know. But I mean, I think we have all the information as long as, you know, we could approve it subject to final approval by the township.
I'm okay with that. As the organizer, is Nathan in the waiting room? Or organizer?
No, we don't have Nathan.
Okay. Well, I think Pam's correct, as long as it's approved by our engineer, installed according to that. And somebody wants to make a motion and make sure the motion includes an approval by the township engineer.
I'll make the motion to approve appeal number 20-1886 for the installation of an underground seepage pit, subject to the approval of the township engineer to mitigate from the 24.1 with the additions down to the current 21.1. By that correctly?
I think 21.4, I think.
Yeah, 24.1 to 21.4.
Is there a
I'll
second?
Do we have any public comment on this one?
Yeah, I was just going to ask, is there any public comment? In?
Oh, we have no public comment.
Okay.
Is there any discussion by the board?
No.
Well, with that being said, I'll entertain a vote. All those in favor?
Aye.
Aye. All those opposed? The ayes have it. Your motion is your appeal has been approved, and get together with your engineer or your guy, and of course get together with our engineer. That's the final approval.
All right. Thank you much.
Okay. Thank you. All right. Thank you very much, sir. All right. Let's go to our next one, which is the Swind. Okay. Next appeal is 20-1887, David and Joanna Swind. If they can come up or come into the meeting room, come into the room. And Adam, is there any exhibits once they come in that you want to mark up?
Can I real quick? I'm recusing myself from this one.
Oh,
Well, it's my neighbor, and I'm in the zone, so I got a notice. So I'm not taking a position against it, but I'm
yeah, okay. All right. So I think you have to do that. You have to recuse yourself. That's fine. I'm sure the township's going to want to participate in this one as well. But if we can bring them in, swear them in. Bill, are they here?
Yeah, they're here. Bill, you can swear them in, and then I'll mark the exhibits.
They solemnly swear the testimony about to give will be the truth, so help you God.
Yes.
All right. We'll mark A1 as the application, A2 is the site plan, A3 is the impervious surface breakdown, B1 proof of publication, B2 proof of posting, and B3 is the notice to the neighbors.
All right. Mr. Swind, I believe I got that correct.
Yes.
Do you want to explain what you're trying to do to the board, with the board?
So yeah, we are putting a pool in. We have a young family, and we obviously understand that there's zoning restrictions, but we feel that what we're asking for is, reasonable in our request for the 500-year floodplain. We've been here 4 years. We've had no issue with flooding in our yard. There was we know the previous
owners.
and they had a pool here. There was no issues.
The house was built with a pool. It got jackhammered up a couple of years prior to us purchasing the house. There's never been flooding issues.
All right. If anybody wants to say anything before I ask Barb for her comment, because I'm sure she's going to want to participate.
Anthony, do you want to? I mean, there's only 4 of us now voting, so.
Oh, yeah. Thank you, Matt. There's only 4 of us because your neighbor's recusing herself. So if it's a tie, you lose. I just want to let you know that. So you have the option to continue this when there's 5 members. It's up to you. Do you want to go continue on, or do you want to continuance when there's a full board of 5 members? If you get 4, if it's a tie, you lose. You understand?
I don't think we have.
Well,
Have
it would be 3 members because you can't have 5 if Pam is
She's out. Yeah.
recusing. Basically, if there is a tie is a no.
Right.
Whereas if it's 4-0 or 3-0 or whatever,
If
you're
there's
fine.
a 2-2.
Or 3-1, you're fine.
Yeah, right. Yeah, I want to explain that.
Okay.
It's possible. It's possible with 4.
Yeah,
Generally, it works out, but just wanted to let you know you have that option.
that's fine. We'll move forward. Thank you.
Okay. That being said, I know Barb wants to say something. Of course, the members of the board are always welcome. But Barb, did you want to ask questions first about this? Because I know it's in the floodplain, this installation.
Yes, and that's it. I couldn't hear correctly. Did you say the prior owners had a pool in the property?
Yeah,
Yeah.
the original house was built with a pool, and the pool was on the property until probably a couple years prior to us moving in. They had it jackhammered out. It was in a different location. The pool was, if you guys have the copy of the plan, it was all the way to the right. So it was actually fully in the 500-year flood plan, where we're putting the pool all the way to the left, where just the back corner is in the flood zone.
And you said they had it jackhammered out, or was it filled in?
It was jackhammered out, and the township has permits. I believe Miraz's did that work because we did have those pulled prior to buying the house.
So the new pool, is it going to be of a similar size?
I believe it's going to be smaller. If it is I believe the pool, every house, I think, in the neighborhood, or the majority of the houses, were built with the same rectangular concrete pool. The pool that we're putting in is smaller, if that is the size that was here. I'm not certain the exact dimensions of the pool that was here.
Is that
I
going
do
to,
have the dimensions of that pool that was built
Okay.
back in the 70s. The old pool was 20 feet by 38 and a half feet.
I could, 20 by 38 and a half?
Correct. And the pool is in the 100-year floodplain, not also the 500-year. It's in both.
All right.
Okay. And you are aware that if the board were inclined to grant your relief, that you have to comply with certain provisions set forth in the ordinance, specifically that you need to be aware that there could be an increase in your premium rates for flood insurance. Are you willing to accept that risk?
Yes, and we currently don't have flood insurance. Our house doesn't qualify for flood insurance.
Was that recent that they modified it, or was
No,
it?
it's never had flood insurance. The neighbors behind us, what street is that? They require flood insurance.
On Esther, I believe, has.
That's not,
Not
David Terrace.
David Terrace.
David Terrace.
Yeah.
So if you can see the house that's built in behind our yard, that's the whole house is in the 100-year flood plan. Those houses have flood insurance. This part of Gloria Lane does not.
Okay, and I only have another question. On your impervious surface chart, it says proposed construction is 427 square feet. Is that the coping that's going to be around the proposed pool, the deck area?
We are doing coping. I know Steve from our pool company is on this call. He would be able to answer that better.
Yeah, that's correct. That's the decking.
Maybe you should be sworn in, sir.
Yeah, can we just swear Steve in, please?
Sure.
Steve, do you solemnly swear the testimony about to give will be the truth, so help you God?
I do.
Can you tell me your last name and spell for me, please?
It's Faz, F-A-H-S.
Okay, thank you.
Okay, so the total decking is 427 square feet. Oh, well, that includes the pad for the filter also.
Okay, how big's the pad for the filter?
The filtering pad is 15 square, filtering pad is 15 square feet.
So is it roughly like a 3-foot wide concrete decking?
Basically, it's a concrete patio around the pool, and the total impervious comes out to 17.3%.
And the proposed location, is that because it's in the furthermost rear corner of the property?
We have the pool pushed as far as we could, basically, as far out of the floodplain as we could get it.
Okay. I have no other questions.
I see there's no, you don't have an impervious surface issue, so is this a floodplain issue? Is there something that we have to do because they're installing it in the floodplain? They have to do anything else to add bushes around anything? Jim, I'm not even sure.
No, it's the zoning reg is because they're in the 100-year floodplain.
Okay.
For the work.
Again,
We're in the 500-year floodplain, not the 100-year.
You're in both.
You're in both. I'm looking at your plan, and part of your pool is in the 100-year, and part of it is in the 500, and part of it is outside of both of them.
Yeah, there's a little bit at the deep. Yeah, I see a little bit at the deep end of the pool is in the 500 year. I'm sorry, in the 100 year.
Okay.
Thanks, Jim.
Okay.
Is there any type of filling going on in either of the 100-year or 500-year? Are you raising the grade to level that off?
Well, the grade, the elevation on the grade is basically the yard's relatively flat, so the road wouldn't be much grading at all in that floodplain area.
So you're not raising the grade at all. You're just keeping as is.
Right.
I'm asking because that area drops down into the stream.
You understand what he's saying? Are you changing the grade at all?
See, the stream's back here.
If
you... I may, Tony, the grade is only being altered by not more than half a foot. It's basically at or near grade with the pool.
Thanks, Jim.
Okay. Thank you, Jim.
And just piggybacking on what Barb said, under the ordinance, whenever a variance is granted in the floodplain, the granting of the variance, the decision should state that the variance may result in increased premium rates for flood insurance, and also that such variances may increase the risk to life and property. So any decision should include that language, and as long as the applicants are okay with that, we're okay.
Is there any public comment on this? Anybody in the waiting room?
Oh, shoot. No public comment.
None.
Are you maintaining the existing fence, or are you putting in a new one?
We have a plan to put in a new one, but that's not part of the pool. They're not putting that fence in right now, but we have a plan to put in one.
Okay. Just be mindful when you do. Be mindful of the floodplain. You want to make sure that you're not going to create a dam, and that'll basically blow your fence out as well as cause problems. So.
Okay. Thank you.
So this makes sure I'm understand this. As long as they don't change the grade more than a foot, as Jim said, there's no problem with this going into this floodplain area. They don't really need any mitigation efforts, but obviously you need to submit a plan to our engineer, and he will, of course, inspect it, and as will our other inspectors. So I just want, is that correct, Matt? They really don't need to do anything other than get our approval?
I mean, my concern is making sure they're not exacerbating a flood issue, especially within the 100-year.
Mm-hmm.
The 500-year is not as regulated, but you don't want them to add fill into a flood area, because then they will impact somebody else's property. It may be minor, but it may be substantial, and that's what the town really wants to make sure is they're not going to be saddled with. So,
okay. So they need to submit a plan showing all these, the installation and any kind of grade changes, period, even minor changes.
Yeah, I would request that when they submit this to the town engineer, it goes to the town engineer, right, Jim? Not you?
Correct.
Okay. I would request that when they do submit it to the town engineer, that there is a grading plan associated with this, so that we can, or our town engineer can determine that there is no change in grade. Or if there is, there's a alternate reduction in grade someplace else on the site, so that we're not increasing anything offsite.
Right. That's what I was asking earlier. All right. Are you guys okay with all that?
Yeah.
I'd be okay with it.
Okay.
I'm fine with it.
Anybody else comment? Anybody? Looking for a motion.
I'll make a motion to approve appeal number 20-1887 for the installation of a pool within the 100 and 500-year floodplain as depicted on whichever exhibit this one was, subject to submission of a grading plan to the town engineer for final approval.
Do we have a second?
Don't we need to add the comment?
No. Well, if you second, then I'll ask for comments.
I'll say, does this require also, as part of the motion, the compliance with the regulation?
Yes, Peter. Yes, Peter.
I think you said that in your motion, did you not, Matt?
I did not mention that. So subject to what section is that? I've lost track of it.
It's 200-59B 1E 1 and 2.
Thank you, Adam.
That just rolls off the tongue.
Doesn't it, though? Doesn't it?
I don't know if anybody should memorize that. That being said, anything else, Pete?
No, that was just wanted to make sure that was in there. That's what they're required. So,
okay. Is there a second then?
yes, second.
Any discussion? All those in favor?
Aye.
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 All those opposed? The ayes have it. There you go. Thank you very much.
There you go, guys.
Thank you.
Appreciate it.
Thank you.
Great. All right. We're moving on. Next appeal is 20-1888 Mons Construction. From what I see here, those he can step up, be sworn in, and when he does, Adam can entertain.
Can you shut
enter
that
the-
off? I have no idea how to shut it off.
Oh, what happened? Oh, what happened here? I lost my thing. Hang on, guys.
We still have the previous appellants on. They didn't make the switch cleanly.
Okay.
Well, I'm the next one, I believe.
Are you
you are.
Mons Construction?
Yes. Well, I'm Shannon
The
Lopez.
owner.
Yes.
Yeah, I'm here, Colin Craig from Mons Construction as well.
Okay. All right. Bill can swear you in, and then Adam can enter exhibits.
Hey, let me swear you both in. Do you both solemnly swear the testimony about to give will be the truth, so help you God?
Yes.
We do. Yes.
Okay, we have the application is A1, site plan is A2. the stormwater calculations as A3, B1, proof of publication, B2, proof of posting, and B3, notice to the neighbors.
All right. If you guys can explain to the board what you like to do, we've already seen your appeal, but can you explain to the board what you're trying to do?
Yes, thank you very much. So we moved here about 9.5 years ago, and our house was already apparently over the impervious earth due to a pool that had been installed quite some time ago. And at this point, we are hoping to put a roof over our deck to expand the time we're able to use our outdoor space, given all the restrictions that we're all under right now. It'd be great to be able to use the deck probably 3.5 seasons out of the year.
All right. Is the township participating in this by any chance, Barb?
No.
No.
Okay. I do see you are increasing the impervious surface. What is the impervious surface required in that area? Is that 21%? Am I reading that right? James?
I believe we're, oh, sorry.
Yes, I believe it's 21%.
Okay, and you're currently at 20.74, and you looks like you're going to be 20. Is it 22.79? Am I reading that right?
Colin, do you have that? I thought it was 23.5, not to make this worse.
Hard, right? And this,
There's
I did
two
have that.
options. There's two options. If you could explain that,
please.
I'd appreciate it.
23.5 on here too.
Okay. So the two options were a partial roof and a full roof over, only covering part of the deck and covering the full deck. Our very strong preference is to cover the full deck. So that would put it at the 23.5.
I don't have email on that computer.
We didn't know how to get into that.
How did you do it? You clicked on the
We,
Download.
Could we silence Stephen, please?
I think that's the guy from the previous, so if we could
And then I.
mute him or
Another
take
person?
him off.
Well, that's the last one I got. And hopefully I don't do any more because I'm next one, what I'm doing, tell customers, if they need a variance, I'm going to tell.
Thank you.
Thank you. Okay, I think I understand what you're trying to do. You're trying to put a roof over the deck, correct?
Correct.
Your
Yes.
deck is quite large. And those two figures represent a partial or a full roof. Is that correct?
That is correct.
Now, you're already over the impervious surface. Did you do any work on that property without permits, or did you buy the house with that just like it is right now?
Bought the house as it is right now.
Okay. So we don't know what you exactly want. Either way, you're going to need some kind of mitigation effort because you're over, right?
Mhm.
21. And the partial roof, what would the partial roof be again? 21.5? What did I hear?
I think that was the 22.79. Honestly, I didn't realize that was still on there as one of the options. It is our very strong preference to go with the full roof, which would put it at 23.5. We have done the calculations for a dry well, which I believe is for the need would be for 118 cubic feet. So I think it's a 10 by 6 by 5 to get us to 120 cubic feet in order to do that mitigation.
Now, that's incredible that you did that, but that's nice. On your roof that you're putting over there, you'll have obviously rain coming off that with gutters and spouts. Are they going to be designed to be going into the dry well?
That was, pending a site visit. We were kind of going to see how this meeting went and then, go through the mitigation then. So that is our plan. I mean,
because I would want that, since it's a roof, and I know how roofs can be when you start to combine them, you can get a lot of runoff. And I would, not just a dry well for the property, but getting rid of that rain that's coming or that water that's coming off the roof to go into that without flooding the property first. At least that's how I feel. I can defer to one of the members of the board if I'm crazy here or not, but I know that's what I did at my house, so I didn't have the water hitting the ground. And either you're already doing the work, so it wouldn't be that much any more difficulty. Anybody got a comment on that? Anybody? Matt? Pete?
Yeah, generally I'd agree with you, Anthony. I would prefer to see the roof runoff going into the drywall.
Yeah. Okay. Would you guys have an issue with that? You've already figured out your size, and of course that's based on our engineer's approval. Would you know? I'm sorry.
Did Jim confirm that?
Well, Jim, I didn't ask Jim if he confirmed it yet. It's based on his approval or the engineer's approval. Jim,
Okay.
their figure's accurate. She sounded pretty accurate. I mean, I don't know.
Yes.
Okay. And that would include the runoff from the roof. I mean, I'm just asking. Because that's how I would I think the board would want that, the runoff of the roof to go into this dry well.
I think I'd want that too.
Yeah. All right. Okay. So there's no disagreement there. Jim seems to be okay with the size, but I got to defer to a couple other guys. The township's not participating in this? Guess not.
No, I'm sorry. No, we're not.
Okay. I would like to defer to my colleagues if they have anything before I go to public comment. Anybody want to add something? Pam? No?
Nope.
I like how they're prepared.
Nope.
Yeah, they did. Yeah, that's pretty good. What was I going to ask? No, it sounds like they're on the ball. Anybody got
Thanks, Colin.
Anybody got any?
No problem.
Well, we should see if there's any public comment.
It is public comment, yeah.
No public comment on this agenda item.
No public comment. Okay. All right. Well, they seem to be okay with doing anything we want them to do and follow what we want specifically. So if there's no issue there and they're willing, I'm going to entertain a motion.
Move to approve Appeal 20-1888, subject to providing below ground stormwater mitigation with the roof runoff tied to it, subject to township approval.
What impervious rate or effective impervious rate are we taking them to?
Back to
Effective impervious rate of 21%.
21, is it? Or less?
21
That's
is
what they're allowed.
Is that what
Yeah.
it was?
Yeah.
21? Oh, that's what it is.
Yeah, and that's what their application is for.
Right, you're correct. My mistake. Okay, is there a second?
I'll second that.
Was there any discussion? Damn, nobody? All right, then now, who's in favor? Everybody's in favor, say aye.
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 Anybody opposed? The ayes have it. Okay, you got it.
Thank you very much.
All right, thank you.
Thank you, guys.
Thank you.
All right, give me a second, guys. I gotta get my stuff in order here. That's that. All right, we're moving on. Hold on. I lost my areas. The next appeal is appeal number 20-1889, Christopher Schoffler. If he can step up and be sworn in, and Adam can enter the exhibits. Are they here?
Yes.
Okay.
All right, we have the application as A1, the site plan as A2, impervious surface breakdown as A3, A1, proof of publication, B2, proof of posting, and B3, notice to the neighbors.
Hey, sir, do you solemnly swear the testimony about to give will be the truth, so help you God?
Yes.
All right. Explain to us what you like to do.
Okay, my wife and I are working with Niagara Pools to hopefully have a pool installed for our children. Since the LMT club was closed this year, my kids were not able to swim, so we thought it better just to err on the side of if something happens this coming summer to put a pool in our own home. We had the plans drawn up, as you can see. We also had, we're also planning on doing a patio around the pool that you could also see in the plans. Okay. And also.
I see you have the increase in impervious surface.
Yep.
You do. Do you have any kind of plans for mitigation there?
Yes, I think this is where originally I submitted the plans with the understanding Niagara told me they would be denied because I understand we're starting at 19 point something, which is over the 18% that Yardley Hunt allows.
That's correct.
We're being bumped up to, I think, 22.58 is the number I think I remember being correct. And I got a letter back from Mike from the town stating, we're denying your application because you're over on the impervious surface. Please refer to the coding from the town. I believe it is 174, attachment 9.10 and appendix 1. So when I did that, it appears that the engineer who we had hired through the pool company to do the calculation for impervious surface never took into account the tree coverage allowed by the town. At that point, what I did was my father's been an engineer for 40 or 50 years, and I contacted him, and he ran the numbers for the tree coverage. And I think it might be a good idea to put him on because he can kind of enter in what he went through to do that.
Are you trying to say that because of your trees, your impervious surface calculations are not correct?
No, the original ones were not that we submitted to the town. Later on, after we performed the calculations as stated in the coding, we came up with the impervious surface according to what the town would allow.
All right.
If you want, my father's sitting right next to me, and he could better through an engineer's eyes explain to you what's going on because this is all well above my head.
If you want to bring your father in and be sworn in,
yeah,
that's fine.
Please. Here.
There we go. We'll change seats.
Bill, can you swear him in, please?
Sure. Sir, do you solemnly swear the testimony about to give will be the truth, so help you God?
Yes, I do.
Can you tell me your name, please?
Yes, it's Albert E. Schoffler.
Thank you.
All right, Albert, what do you want to tell us?
Okay, basically, when Chris contacted the local code official, he basically said to go refer back to the Township Code 174, and it's attachment 9, and it's appendix I. And in there, there's an allowance for existing tree coverage on the property for the accumulation or the absorption of runoff. And so we went through that calculation. Basically, what it says is that any tree that is over, I believe it was 4 inches in caliper, that you take the canopy area and you calculate the canopy area, and that is applied against any additional runoff on the property. So you get basically a benefit for trees being on your property. And that you'll see on the left-hand side of the plan sheet. There is a calculation showing all of the various trees on the property, the canopy coverage, and what it does, and it nets out. I'm going to pull it up here. Basically, it says non-structural. Whoops. That's it. On the upper left-hand side of the plan sheet, it's basically a non-structural BMP, tree planting and preservation. That's what it's called. It's under 910 and 911 in section 174. And you'll see here the existing tree coverage, 6,000. I guess, whoops, let me get that. 6,214 square feet of tree coverage on the property as it exists. And then there's a volume reduction calculation. Again, that's in 174. And we took the volume reduction, and that's right below there. And it comes out that the volume that is provided is 517, well, 0.83, but 517 cubic feet of volume that is able to be absorbed. And the volume required, and that was the calculation that's on the right-hand side of the plan sheet, shows 143 cubic feet being required over and above based on the pool being put in and the walkway and patio structure being put in. So there's an excess volume on the property right now of 374 cubic feet.
All right. Well, Jim, was what he's saying correct? Because I'm a little confused. Is that part of that? Are these figures correct on the plan?
Yes, and as you had, you're well aware from prior applications, our ordinance allows for several different methods to manage stormwater runoff from the addition of impervious surface. One of which is to maintain the existing tree canopy on a lot. Another one is to plant trees, and one that I know you guys are most familiar with and comfortable with is the installation of underground storage of stormwater through dry well or seepage. Calculations they have on the plan account for the existing trees that are on the lot and the runoff from what is proposed back down to the 18%, which is the
Jim, I'm sorry, you're breaking up.
Let me try that again. They're basically proposing to do runoff from mitigated using the existing tree canopy as opposed to what you're normally used to seeing with a seepage bed.
So they have 3.38% over. I'm looking at the application here. So are they trying to say that these trees are going to make they're going to be that's going to make the difference with the 3.38% or without doing any other mitigation?
Correct.
That's a lot. We don't normally accept that much. And I'll go through the board and they'll ask you some questions too. But the trees, we to a certain point we accept trees if it's a minimum amount of increased impervious surface, but generally not much more than minimum. We can always take a chance, but the board's not usually willing to grant a variance just based on trees.
Basically, I followed what was in the code, so I understand that.
Okay. All right. So that being said, it still looks like you need some kind of seepage bed or a dry well to mitigate that extra increase.
But according to the coding, that's not true.
Yeah, the coding also, if you look at the coding again, it also allows in section 9.10 and 9.11 that if you plant trees in lieu of a BMP structure, for instance, if you use a 6-foot tree, a conifer with 1.5-inch caliper, that's equivalent to a 10 cubic foot absorption. So, we're planning, or I'm not planning, but my son is planning on putting, of course, landscaping around around the pool area. So he'd be very amenable to putting in, tree coverage and everything else around the pool area, additional to what's there already. And in lieu of putting in a structure.
Well,
Jim, what size structure would be required?
Yes, thank you.
If a seepage bed was put in, which would consist of a trench lined with a filter fabric, filled with stone, the dimension would be 3 foot by 6 foot by 15 feet to control the runoff that is from the additional impervious surface.
Would that be for the 143 cubic feet? Because that's what the excess is.
Well, actually, that would just be for the increase in impervious surface. If you account for the full amount back down to the 18%, that would increase the length of that trench from 15 feet to 20 feet.
So you're bringing it down back to the 18% on the property.
Back to the 18%, the dimension's 3 foot by 6 foot by 20 feet, or some other configuration that's comparable. To take it back for just the increase in impervious surface to the 19.
I'm sorry. I guess I'm losing it on that. Just on that piece there.
Prior to the installation of the pool, the impervious surface was already at 19.1 or 4%. So we were already over before we even moved into this house.
And that's why I said just the increase from the 19.2 up to what you're proposing, just for what you're installing,
Correct.
I mentioned the 3 foot by 6 foot by 15 feet.
Okay, that's the, I'm looking here on the left-hand side of the plan sheet where it says volume required. And the volume required is 143 cubic feet, which is consistent, I believe, with the calculation on the right-hand side of, I'm trying to do it here on a phone. The net increase was 640 square feet. That would be the net increase. So it sounds like an awful lot that we're jumping up, for 640 square feet.
Well, you're looking at everything wrong.
Okay, correct.
They took into account 858 feet, I think it is.
I'm sorry?
They used 858 feet in their calculation. Just for the increase, it's 640 square feet.
That is correct.
And since you're adding 640 square feet, you do the calculation, the size is 3 foot by 6 foot by 15 foot.
6 foot by,
Yeah,
I'm sorry,
It's 3 by 6 by 15.
3 by 6 by 15.
Unless you want to build a bigger one, which I don't.
And that'll get you down to the 19 point, I guess, 2 that you have existing.
That would be, get it back down to that level?
Which you had before, yes, existing.
And it doesn't have to be 3 by 6 by 15. It just has to have that volume. So it could be 3 by 3 by 30, just so it has that volume.
Okay, so I'm just trying to do a quick calculation here in the volume calculation. So it was 3 by 6 by 15 was what Jim just mentioned. It's 270 square feet. If I did it correctly.
That trench is lined
Cubic
with
feet.
stone.
Cubic
So there's a void ratio in between.
You have a void ratio to
Sorry,
take
cubic
care of.
feet, yes.
40%.
270, says 270 cubic feet. And I thought the increase was only 140 some odd square feet or cubic feet.
Are you taking into account the void ratio?
I'm sorry?
Are you taking into account the void ratio?
No. Okay,
There's
so
your problem.
that's where the difference is coming in.
Correct. We actually have a spreadsheet calculator available on our website that you can
Okay, that's
go
fine.
and check calculation.
So what we're saying is that's what you need to bring it down to your existing. If you want to go lower at 18, which you don't have to, that should do that. But that, and like Matt says, it could be any configuration that'll fit as long as you have the total cubic feet required. That's what we're asking you to do. This well or seepage paint. That's what we're asking you to do.
Even though the coding, but from the town doesn't, it allows for the coverage of the trees. We're just throwing that out, and we're going to go with the seepage fit instead.
Well, the coding for the town also has a impervious ratio that you're exceeding, so you're voiding the township code yourself. So we can either come to an agreement, or you can argue about trees.
Right.
Mm-hmm.
Up to you.
And just to let you know, our position is we like trees, but there's no guarantee that the next homeowner is going to keep them.
Okay, so this is kind of just a not a stopgap, but just a precautionary measure for down the line too.
Correct. It's better than putting all your eggs in one basket. You have trees. You also have a structure.
Okay, and is there any specific portion of the yard where this has to be located in? Because I know the drainage swale for the two properties, myself and my neighbor in back of us, is between the two properties. So the natural swale of the yard is actually at the back fence line, or can it be located anywhere on the property?
No, ideally you're looking to locate it where it's going to actually catch the new impervious material.
So that would be the back property.
We rely on the township engineer for final approval and locations.
Okay. Understand.
Yep, that's what we're going to require.
Yeah.
And Is Barb here? Is the township involved with this?
No.
Township's not taking part of this application.
Yeah, we're not real receptive to trees for that kind of volume increase because, as Pete said, a lot of times new owners, they don't last, they don't know, and we it ends up being ineffectual.
Yeah. Okay, that makes sense then.
Yeah, basically, like we were saying, we follow what the code official said to follow, which was 174 submission.
So if you're willing to install something like that that's approved by the engineer, especially location and volume, the board may be willing to grant this.
Okay, so who do I would agree to it because it makes sense how you explained it down the line. Who would I have the pool company then draw up plans, the engineer that we use to draw plans for this size pit? And then submit that and then resubmit that, or?
Yes. You would submit that to our township engineer for approval.
Okay.
That sounds fine. Yeah.
Well, if you're okay with that, do we have any public comment?
No public comment.
No public comment. Anybody else on the board have something to say?
I'm fine with the plan.
Excuse me, Mike?
I'm fine with the proposed solution.
Okay. You want to make entertain a motion then?
Sure. I'll make a motion to approve appeal number 20-1889 to install a stormwater management system underground to take the proposed 22.58% impervious cover.
Excuse me, I'm sorry to interrupt. Can we please close the screen share? Whoever's sharing their screen, thank you. Go ahead. Sorry for the interruption.
Not a problem. I believe I left off at, we're going to mitigate down from the proposed 22.58% down to the existing 19.2%, subject to approval by the township engineer.
That sounds good.
Second.
Okay, we have a second. Is there any discussion?
Nope.
Nobody? Okay. All those in favor? Say aye.
Aye.
Aye. All those opposed? Opposed? Nobody? Okay. The ayes have it. There you go. Thank you very much.
Oh, thank you.
Okay. What's that one? Now where are we? Oh, now we're back to the other one. Damn it. All right. That's it.
Excuse me, Tony.
Yes.
This is David, the moderator. We're going to be bringing in a number of people.
Okay.
Most of them are participants, are party to this agenda item.
Okay.
But there is also going to be some public mixed in. So what I thought we would do is bring everybody in and then have everyone mute up, turn their cameras off. And then when you're ready for public comments, there's a total mix. There's about 20 people.
Wow.
So how about we do that? We'll bring everybody in, have everyone mute, and then you can call on who you'd like to unmute.
Okay. That being said, our next appeal would be 20-1881. Challenge the validity of the mixed use overlay. Darwin Dobson, Lawrence Borda, and Brian McNamara.
Excuse me, I'm recusing myself from this.
Again?
Yes. I'm personal friends with one of the applicants, so I need to recuse myself.
All righty. Okay.
And I was going to say, I think this is going to be a long appeal. I think it was the last appeal. So if the board and the chair do not mind, I'm going to sign off because I'm recusing myself. So
I have no objection. Adam?
We'll miss you.
Thank you. All right. Good night.
All right.
Happy New Year and happy holidays.
All right. Let's step up. I assume they have to be sworn in again.
Yeah, the applicant should be sworn in.
All my papers ready for this one. Bill, you there?
Down there. Sir, I'm going to swear you first. Do you solemnly swear the testimony you're about to give will be the truth, so help you God?
You're swearing in Larry Borda?
Okay, Larry, thank you.
Yep.
And how
All
about
right.
the
You
other
wanna jump
two?
all in?
The other two, Dobson and McNamara?
Yes.
Are they
I
on?
don't think they're going to be on tonight.
Oh, okay.
Okay.
All right.
I'm going to, I'll mark the exhibits. Eric, if I miss anything, let me know. I do have a couple of the other ones that you just submitted more recently.
Yes.
So I'll go through them and hopefully everything will jive with you. I'm going to rename or renumber some of yours just under our numbering system.
Sure, no problem.
We have the application as A1, the site plan as A2. There's an addendum, which I believe is 7 pages, explaining some of the rationale for the application. That's A3. The amended ordinance that you have attached as Exhibit 1 is A4. The Planning Commission memo that you have attached as Exhibit 2, we have as A5. The declaration of covenants and restrictions that you have as Exhibit 3, we have as A6. A7 is going to be the August 17th Board of Supervisors special meeting minutes. That's when you have marked as 4. A8 will be the August 31st Board of Supervisors special meeting minutes, and that's when you have it marked as Exhibit 5. And then A9 I have as the impact on nearby properties, which you submitted today, I believe. And then A10 is the traffic impact graphics that you have, which is 5 pages. B1 is going to be the proof of publication, B2 proof of posting, and B3 notice to the neighbors. If I missed anything, we can add it, or if you have any additional exhibits, we can, I guess, start at A11 for anything additional that you would present tonight.
That's fine. Tony, don't you need to sit? There's only 4 members of the board
Yeah, I
present.
was going to say thank you. There are only 4 members of the board. I kind of think we're not going to get through tonight because there's so many. We have a 10 p.m. curfew. But yes, there's only 4 members of the board tonight. In the event of a tie, you lose. You have the option of continuing or moving on.
Well, what do you say at this point in time? We can start presenting evidence. I know there are going to be some motions made regarding some procedural matters, and suppose we just move on. And if we get to the point where it's 10 o'clock and we're up for a vote, we can decide at that point. If that is okay with the board.
It's okay with me.
And Tony, just to note, since Pam recused herself, there's only 4 permanent members available. Since we do not have any alternates in place, we would always have a situation where we only have 4 members voting on this.
Yeah,
that's correct.
Yeah, the only thing we could do is if for instance it was continued and someone else was not available, then we would have 3. Or if Tony just kicked someone else off for so we can have an odd number again. But that's an option as well if it went to another meeting or something.
Well, I'm okay with the 4. I mean, I don't want to kick anybody off. I firmly believe this is going to be continued tonight because of all the public participation. So I don't see that as being an issue tonight. Now, again, though, next meeting, there's still only going to be 4, as he says, because Pam has to recuse herself. So we have no alternates.
Barbara, do you have a question?
Actually, I have before we begin testimony, there's 2 matters I think we need to address. First of which, a motion for intervention was filed by Mr. Harris, who represents the equitable and legal property owners that I believe needs to be resolved preliminarily. And secondly, Mr. Harris filed a written motion for dismissal due to lack of standing and jurisdiction. And I was going to make a verbal motion for dismissal on the basis of standing and jurisdiction. So before we could get to even the merits of the case, I believe those items need to be resolved preliminarily.
All right. Who's Mr. Harris?
I'm Mr. Harris.
No, there you are.
Hi, my name's Steve Harris. I'm the attorney that represents Shady Brook Investors LP, legal owner of a portion of the property, and ELU DeLuca Yardley LLC, equitable owner of the remainder of the property. And we are the property owners that own where the projected Wegmans, the 55,000 square feet of retail, and the 200 apartments are going to be built. And therefore, we're asking to intervene in this matter as parties, as legal and equitable owners of the party subject to this property subject to this ordinance.
Has he been sworn in?
No, I don't get sworn in.
He's an attorney. He doesn't.
He's an attorney.
Sorry, I'm sorry, I missed that part. All right. Again, Barb, what did I miss? That we have to work with this first? I missed something there. Or if Adam can explain it to me, what Barb was saying.
Well, Mr. Harris's clients own the property that is subject to this development and is part of the and they're obviously requesting party status, and they want to intervene in this to oppose the application. They've they've submitted a motion to dismiss, which I believe Ms. Kirk has, joined in on behalf of the township to dismiss this. So there's a couple procedural issues with that, as far as whether, and in the motion, challenging the standing of the applicants to challenge the ordinance.
That's the one we just received. Yes.
I'm sorry?
That's the one we just received yesterday.
Correct.
Yes. Okay.
So I think what may make sense is for Mr. Goldberg to, offer either testimony or evidence or argument about the standing issue. And after that determination, depending on how the board, whatever determination would make, would dictate whether we're kind of done at that point or whether we proceed on the merits.
Adam, if I can, initially, I think the board has to decide whether or not they will grant us party status to intervene. I think we've got an absolute right as the property owners, but nonetheless, I think the board has to act on that. Number two, assuming that the board does grant us party status, there are actually two items in our motion to dismiss. The first item is that the zoning hearing board doesn't have the jurisdiction to hear the procedural challenge that was brought to it. That has to be brought in the Court of Common Pleas. And then secondly, for the reasons stated in the motion as well, that the applicants don't have standing because they don't have an interest in the application that is different than the public at large.
Okay, that's up to us. And so does he need to get party status? Is that what he's saying?
Well, Tony, as the chair, it's your discretion to grant it. Obviously, they're the property that is the subject of the ordinance, and they're noticed from as a result of that, we received notice. So from a legal perspective, they have every right to request party status in this matter.
They should have party status. I have no problem with that.
Okay. So from that, so that's, the first thing. And as Mr. Harris stated, there are two issues.
There's two items, yes.
There's three challenges that Mr. Goldberg's clients are bringing. One of them is procedural, and two are substantive. And the first part of the motion to dismiss is whether whether the zoning hearing board has jurisdiction, the authority to entertain a procedural challenge to the ordinance. And Mr. Harris's position is that that the board does not. And obviously, so I guess Mr. Goldberg can respond to that.
I understand that part. Whether they have we have procedural situation there. But the other things to this, the substantive, the amendments, the ordinance off-site traffic, and the other one with the spot zone, that's and the applicant's standing on this issue. I'm not sure that the procedural thing comes into play if there's no standing. Am I incorrect here? I don't want to rule.
That's correct.
I'm not saying where I'm at. Just want to make sure I'm clear. And I can't speak for the board, but if I look at this correctly, and I hope I am, and my board members, please interrupt me if I'm making a mistake here. I'm looking at the applicants, and I'm just trying to see what their standing is on this, and I understand it. But if there's no standing, and I'm not saying there isn't, if there's no standing, then there's no procedural issue. And they wouldn't follow up with that, at least not with this zoning board, unless I'm incorrect here. Adam, if you can correct me on that.
There's two ways you could do it. Kind of, you could make a determination about the procedural challenge outright and see if make a determination on that, and then go to standing, or you can do standing first and then decide everything. Well,
all right. This one again, if we decide on standing, then there's nothing to decide on procedural. Is that correct?
That's correct.
Sure.
Yes.
That's what we're doing. I'm just saying, let's make sure I understand this, and I hope the rest of the board understands it as well.
Can I ask just a quick clarification? Mr. Harris, do you represent all of the owners or just some of them?
Yes. All of them.
Those two questions. All of them. Thank you.
Quick question to Adam here. Do we need to have a motion to give them status?
To give Mr. Harris's client status?
Yes.
No, it's within the discretion of the chair. So as long as Tony grants it, which he has, then we can proceed.
Good.
So I guess, Mr. Goldberg, if you want to just discuss the procedural challenge as far as jurisdiction and also the standing arguments. And I don't know if you need to present evidence or it would just be argument, but I guess that makes sense to start with you.
Well, it will be a combination. Good evening, everyone. My name's Eric Goldberg. I'm here tonight on behalf of the applicants. And I realize this is a little bit of a different situation. It's a little bit of a unique situation. And just to kind of take a step back and see where we are in this. The township, as you're aware, adopted the overlay district. It consisted of 8 parcels. 5 of the parcels are either owned or controlled by Shady Brook Investors and ELU DeLuca. They're the 5 parcels that are really the subject of what's going to be developed. However, there were 3 other parcels that were also rezoned as part of the overlay district. What is being proposed is that the developer will construct 200 apartments, 100,000 square foot Wegmans, and about 55,000 square feet of retail on the 5 parcels that are collectively being referred to as Prickett Preserve. They're the 5 parcels represented by Steve's clients, and those parcels are 20-1640, 20-16-40-1, 20-16-39, 20-12-1-3, and 20-12-2-2. And they total about 37 acres. It is my client's position that the overlay district was unlawfully enacted. We believe it is contract or spot zoning. We believe that developers are possibly paying more than what is allowed under Section 503A of the Pennsylvania Municipalities Planning Code. We believe that a restrictive covenant guaranteeing about $6.5 to $7 million in improvements was signed by the developers, and perhaps that was done in violation of zoning law, the MPC. It was noted that upon the approval of this, that this approval is contingent on there being a Wegmans, and that's not really the purpose of zoning. Zoning is supposed to be about appropriate use of land. not necessarily who can pay the most improvements, or what particular store is there. My clients filed an appeal from the supervisor's decision to amend the ordinance.
Objection.
Eric, can you stop for 1 second?
I thought you asked Mr. Goldberg to provide his argument as to standing. He's getting into the substantive nature of this application and not addressing the preliminary issue of standing first.
And that's where I was going with this. I just wanted a little bit of background so it's clear as to where my clients are coming from. The appeal was filed. There were two components to it, as noted. One was substantive, which we just discussed. The second was procedural. I agree with what was stated in that the proper venue for procedural appeals is the Court of Common Pleas in Doylestown. This was filed with this board out of an abundance of caution because I wanted to make sure there was some jurisdiction. So we didn't want a situation where it was complained of that the Court of Common Pleas didn't have jurisdiction for the procedural matter and this board didn't have jurisdiction. So it was done out of an abundance of caution. In terms of the standing issues, people who have standing are typically referred to as aggrieved persons. In order to be aggrieved, you typically need three things, as the cases indicate. There has to be a substantial interest, there has to be a direct interest, and there has to be immediacy. In terms of substantial interest, that means discernible from the general public. In terms of a direct interest, the matter causes harm, either can be pecuniary or non-pecuniary. In terms of immediacy, it's a causal connection. In this case, what the applicants will show via testimony is that there's a pecuniary loss of value from the overlay district if the property is developed as proposed. There will also be specific traffic issues, not to the overall population. For example, I live about, 15 minutes away from the Prickett Preserve. I drive the bypass. I don't necessarily have standing because issues there are common to everyone. It's not a discernible interest. However, through testimony, it will be shown that there is a discernible traffic interest. In terms of the cases, and I had the chance to review the memo that was supplied by Steve in support of his motion, I disagree with the interpretation as to what the cases indicate. There's one case called Loftman, and all of the other cases, quite frankly, talk about the same thing. And Loftman, it's specifically noted that property owners need not establish pecuniary or financial loss if the property is in close proximity to the subject property. So what that means is if somebody's property abuts the property in question, they're automatically presumed to have standing. There's no ifs, ands, or buts about it. However, what those cases do not say is just because you are not next door or not in a couple hundred feet away doesn't mean you automatically do not have standing. Rather, you get standing by showing the three aforementioned factors of substantial interest, direct interest, and immediacy.
Excuse me, Mr. Goldberg. Excuse me.
Yes.
Excuse me. This is the Bill Campbell, the court reporter. I got knocked off of this meeting.
Oh. You're back now, Bill?
Yeah, I'm back now, but I lost my mind, went out at right at Steve Harris. Objected, said he had standing.
Well,
he got knocked or something.
Well,
so
we can't recreate it. I mean, it's being taped, so we'll have to
we'll have to go back to the tape.
Yeah, and you can.
Questions. It's being. But I'm still trying to understand where he thinks this. It seems to me there's the standing issue. Again, I don't want to interrupt you, but to say that you have standing when you don't have to live next to the person, and where do we stop? I'm not saying you're right or wrong, but I don't agree with that myself about your standing issue. Yeah, sure, the people next door, I certainly agree with that. And if you're going to put in a garbage dump there, of course, you might have standing if you're 2 miles away. But as you say, I live 15 minutes from there too. Traffic, I'm trying to get where you feel you have standing. I'm not really getting that part, but you can continue on.
Sure.
I don't agree with you. I don't know where you're even aggrieved.
Mr. Chairperson and Mr. Flagger, there is one additional issue, and I'm not sure if anybody is aware of this. There's a jurisdictional issue too, in that besides the procedural challenge, these three parties who filed this application have also filed a complaint through the Court of Common Pleas of Bucks County, setting forth the same arguments and seeking the same relief, which was docketed with the court on September 30th, 2020. You can't argue the same issues before two different judicial bodies. And in this case, the Court of Common Pleas would have a more exclusive jurisdiction over the matter than the Zoning Hearing Board.
Well, we're kind of getting a bit astray. I mean, I'll certainly address the issue you raised, Barbara.
Well, that is a good point. If you filed an appeal with the Common Pleas, that's interesting. Go ahead.
Initially, before we go on, the court reporter, Bill, is that your name?
Yes.
That's correct.
Okay. Are you able, from the tapes, to recreate, my wonderful 5-10 minute speech before, rather than having to reiterate that, which I'm sure will thrill everyone?
Yeah, sure. Sure. If I can do it for the tapes, no problem.
Okay. And Adam, the tapes
we
are
have
working?
the tapes.
Yeah, I mean, this is on YouTube now, and the township has everything recording, so should not be an issue there.
Okay. Then, in terms of going back to the standing issue, let's take this to an extreme, and Mr. Chair, to use the example you said, you had asked specifically of, okay, you understand if somebody is right next door, certainly that person has standing, but how far out do you go? If somebody's a little bit further out, why do they have standing? To that, let me ask a couple or let me just look at the reverse situation. Suppose something's built in the middle of a cornfield and there are no properties around it. Does that mean that no one could ever challenge anything? It is based on what you're saying. And I don't think that's the intent. And I don't think that is the law. Also, in terms of what the cases talk about. Again, the cases talk about how if you are next door to a property or you're within a couple hundred feet, you automatically have that standing. They don't stand for the opposite position, which is just because you're not that far means you automatically don't have standing. Instead, if you can show a substantial, direct, and immediate interest, then yes, you would have standing.
I'm still waiting to hear that.
Next door.
I'm still waiting to hear your reason for that.
Sure. Well, a lot of that will come through testimony. I'm trying to initially address this and basically offer, to a limited degree, kind of an offer of proof. But we have witnesses who will testify that if this development is constructed as proposed with the 200 apartments, the Wegmans, and the 55,000 square feet of retail, what you will have is a situation where there will be a loss of property values because we don't believe this development will be the successful development that it's portrayed to be. And there will be a loss of property values for certain people within a certain distance. That is one of the things. There's also someone who has other traffic issues. I mean, people have different traffic issues depending on where you live. And there's a concern certainly with Mr. Board in particular, who lives at 508 Heritage Oak Drive, which is about little under a mile away. But there is a concern of his loss of property value, and there is a concern regarding the traffic. So yes, he has immediate, discernible, substantial interests that are different from the general populace. Those interests are different than me, who, as I said, I live 15 minutes away from this site.
Well, you're saying that, and I read the whole thing here, and I see what you're saying. He's how he feels he may be aggrieved, and I think a lot of that is subjective and not necessarily correct. I can't agree with all that. I'm just saying it's me. I can't speak for anybody else here, but I live in the area, and I'm just wondering how you feel that he should have standing when you're saying, based on this case law, that in fact, at one point you mentioned up to 13.8%, and then mentioned, well, it's more closer to 1.5. So you kind of contradict yourself. So I'm just wondering how you're aggrieved here, and I would think that is pertinent to this point.
Well, how we're aggrieved certainly is pertinent, but in terms of what's being said, I know the report that you're referring to, and that's one of the witnesses who said, look, there will be, in their opinion, a reduction in property values. It probably will not be the 13.8%. It could be, but believes it will be closer to the lower figure. But that is certainly a pecuniary interest to have one's property value dropped as a result of a development which we do not believe is as viable as is being portrayed. So that is certainly an immediate interest. And again, we have witnesses who will testify. We have a traffic professional who will testify, and we have economic professionals who will testify.
I read those things. I did. And I do feel, I still feel, listen, I'm not saying yes or no here, but I've read those guys' opinions, and I've read the case law, and I still say it could be an increase in property values.
And if I may, I would say if Mr. Goldberg's summary is an offer of proof of the testimony being provided by the witnesses, a concern and a speculation of a loss of property values does not meet the definition under case law of an aggrieved party who requires a direct and immediate interest or harm. A speculation is just that, speculative. There is no direct harm being shown. And as a result, I do not believe that these three parties have the standing within which to litigate this appeal.
And I'm sorry, if I could just address Barbara's point.
Sure.
Obviously, no one's going to know the impact on the property values, and no one's going to know for certain the impact of the traffic until this project is built, which will, we can't go forward and figure out what's going to happen in the year 2024. Based on our information, it is believed that this is what will happen, in that property values will get diminished because we don't believe this project will be as successful. And yes, we are anticipating that, and that is our point, but we believe there will certainly be an increase in traffic. Again, nobody's going to know that for sure, but we believe that increase in traffic, and that will happen. And that's not just for the overall population, but rather for the specific area, particularly around 508 Heritage Oak Drive. And that's what the witness will testify to. But everything is speculative as to what's going to happen in the future. There are no guarantees for anything.
But that's not the case law. The case law clearly says a substantial interest is one in which there is some discernible adverse effect to an interest other than an abstract interest, such as a potential loss of property values. And not only is that cited in the Lothman case, it's also cited in a 2019 case of De Lorenz, which clearly states it has to be an interest or a harm being suffered or will suffer in fact. What you're providing is a belief, a concern, a possibility. It's not a harm in fact.
Well, if I can, if you, and as we all did, read the study that was supplied by the two gentlemen from Temple, that basically says anybody that lives a mile away may have a 1.8% reduction in property value. Even if you accept that that's true, that is not different than anybody else. To have standing, you have to have an impact on your property, your interest that's different than the general populace. And all that's being cited here is hey, there may be an impact on, there may be an increase in traffic. There may be a loss of property values. While we don't believe that's true, the fact of the matter is those impacts are felt by the population in general. That's why these people aren't aggrieved.
And if I could address what Steve said, it is not certainly their interest. There are other people who share those interests. That doesn't make them less substantial, direct, or immediate. There are certainly other people who live around Heritage Oak Drive. The immediate neighbors certainly have that, but not every single person in the township has that. And again, it goes back to the point that was raised earlier of if this position being articulated by Steve and Barbara is correct, then so many instances you could not be able to have anyone seek standing. I mean, who was close enough to this property to have standing? There are very few properties, that abutted or 100 or 2 feet away. And that's not the purpose. The purpose of the law is to prevent what we believe was done improperly.
Well, the purpose, but to have the fact that there may or may not be people that are in the immediate area that have standing that are not raising it doesn't mean that suddenly your clients that live between 1 mile and 2 miles from the property and are simply alleging harms that are identical to their neighbors. That is not a person aggrieved that has the ability to file a challenge to zoning action. And that's our position. And I think that's my client's position. I think that's the township's position. The harms are speculative, but even if we assume that they're real, they're just the same harms that everybody suffers in that area. And that doesn't give your clients the right to have standing. They have to allege something that is different than the public at large. And they haven't alleged it. Even if you assume as true what their report says.
I have to agree with that. And even like you said, even if that report is true, which I think it looks like somebody's opinion. And 1.5%, it could go up 1.5%. I don't feel like that. I don't say it. And he's right. Everybody could possibly be aggrieved, no matter where we go. But what is I think Barbara was right reciting that case law. What is it's more abstract. I agree with that. You just can't have it that simple. You need to give me something more than that.
I think what would make sense is, council's made the legal argument, but I think, if Mr. Goldberg wants to elicit some testimony to support the argument that they're standing, he could do so. Council, both Mr. Harris and Ms. Kirk could cross-examine. And then the board can make the determination at that point as to whether we believe there is standing for these applicants. And if there is, then we can proceed to a full hearing. But I think he's entitled to at least present some evidence on that standing issue. And then we can go from there.
On the standing issue only right now. And I'm fine with that. And a cross-examination and testimony seems like the right thing to do. I think that's fair.
Okay. Then, with that in mind, there are a couple witnesses who are going to be called. Is the ruling at this point just for standing, and that if witnesses have to be recalled to ultimately get to the merits, that will be done that way, or does it make sense to kind of proceed all in one fell swoop?
Standing only.
I think just on standing, because if there's a determination that there is no standing, then it's, we don't need to get into, I'd imagine if getting into a full hearing on all of the merits of the entire application, it's going to be a lot longer. And if we can do it just on standing, we still might have to have a continued hearing, but at least it'll be a little bit more focused as to what the issues are.
I agree with that 100%. Standing on.
I agree as well.
Then if that's the case, First witness that I'm going to call is Gordon Meth.
All right. Bring him in. Have him sworn in.
Sure. Gordon?
Bill, can you swear Gordon in, please?
Sure. Mr. Gordon, you solemnly swear the testimony about to give will be the truth, so help you God?
Yes, I do.
Thank you.
Hello, Gordon. How you doing?
Hello. Good.
Gordon, if you could, please just give a brief description of your qualifications.
We have an offer of proof.
Sure. What Gordon will be testifying to is the traffic in the area around 508 Heritage Oak Drive, in particular, and how that adversely impacts, and also how there is some evidence that is missing from, we believe, missing from the applicant's previous presentation to the Board of Supervisors. So some of it is, we believe that perhaps some of the impact to Heritage Oak Drive was understated when the applicant had presented its testimony to the Board of Supervisors.
Objection. I argue that you cannot relitigate the evidence that was presented at the hearing before the Board of Supervisors. This is to deal strictly with the standing issue and not relitigate all of the traffic issues that were presented. Everybody had full and fair opportunity at the supervisors meeting to make their arguments with respect to the traffic concerns, and Mr. Goldberg's clients had their own traffic engineer there that could offset or dispute what was being presented by the developer or the proposed developer at that time.
We're not relitigating it. We're not trying to relitigate anything that was articulated before the Board of Supervisors in August. That is not the purpose of it. What we're saying is there is some missing information, and what we're saying is we believe that it can be demonstrated that there is an impact to the traffic around 508 Heritage Oak Drive that is unique to the general, that is different and discernible from the general population of Lower Makefield.
And my argument is you cannot have a second bite at the apple by saying that something was not presented at the original hearing. Oh, by the way, we want to present it now. You had your chance. It should have been presented back then.
That's not what we're trying to do.
That's exactly
what you just said you were going to do.
Exactly.
Whether that argument was made at the Board of Supervisors meeting or not is a different it's a different issue. If he's just trying to establish that for a standing argument compared to the argument that you shouldn't pass an ordinance, two different purposes for that. So if you're at the Board of Supervisors meeting and you're presenting that, I don't believe it was for the purpose of establishing standing. I think it was for an attack on the ordinance. Now we're just having it as establishing whether they have standing and how traffic will impact their property specifically. So I think if it's being done in that way, that it would be permissible to have that, limited testimony. I'm not saying to go through everything, but if there's testimony about the traffic that supports his argument for standing, I think they can make that.
Does Mr. Meth have a report?
No, he has the exhibit that was sent earlier, and that's what he will use.
Oh, the Google Maps?
Mm-hmm. Yes.
Okay. We'll deal with that if he refers to them.
Okay. Gordon, if you could, please just give the board a brief description of your qualifications.
Certainly. I have a bachelor's and master's degree in civil engineering, issued from the University of Waterloo. I am a professional engineer within the state of Pennsylvania and other jurisdictions. I have testified before in excess of 60 municipal land use boards for over the last 20 years. And I've represented both boards in nearly 400 applications, applicants in, I believe, about 100 applications and interested parties in about 18 different applications, meaning third parties, not ones directly in it. I also have three certifications from the Transportation Professional Certification Board, where I've demonstrated an expertise through education and experience, or experience and examination. One is professional traffic operations engineer. Another is professional transportation planner. And the third is roadway safety professional. I also am a current member on the International Board for the Institute of Transportation Engineers. And I am the current chairman of the Traffic Engineering Council for the Institute of Transportation Engineers. I'm also a professional
Sorry, I keep losing you.
I'm sorry.
I'm having problems. You say something and then I'm losing part of what you're saying.
Okay. Maybe if I try to go without my headset, it might work better.
Unmute your mic. You got to unmute your mic. We're not hearing anything now.
Unplug the headphones.
You got to unplug them.
Unplugged. Can you hear me now?
There we go.
Yes.
Oh, it's better.
So, do you want me to start over or just jump in from a certain point?
Well, I know you said you had 2 certifications. Can you start from that point? Because I kept losing you.
I have 3 certifications issued by the Transportation Professional Certification Board, which I've obtained through combination of experience, demonstrating experience and examination. One is professional traffic operations engineer. Another is professional transportation planner. And the third is roadway safety professional. I also am a current member of the International Board for the Institute of Transportation Engineers, and I am the current chair of the Traffic Engineering Council for the Institute of Transportation Engineers.
Well, he seems to be qualified.
Could you confirm if you're licensed in PA? I missed that.
Yes, I am a licensed. I've been licensed in Pennsylvania since 2017.
Thank you.
All right. Barb, did you get all that?
Yes. And I just have one quick question. The institute that provided those certifications, is that a state agency or a federal agency?
It's not an agency. It's a independent board. I was actually a board member of it for 6 years. It's called the Transportation Professional Certification Board. It actually certifies internationally, and it is loosely affiliated with the Institute of Transportation Engineers, meaning that they share staff, but they're a separate organization.
Okay, thank you.
All right. I think we can accept his qualifications.
Gordon, you heard what the applicant or what the developers are proposing to develop on this property by virtue of attending the hearings in August, correct?
That is correct.
Okay. So is it correct that what they're proposing is approximately 200 apartments, 55,000 square feet of retail, and about 100,000 square foot Wegmans?
Well, a supermarket. The traffic study didn't specify a brand. It's just based on, but there's 100,000 square foot supermarket, yes, 55,000 square feet of retail, and 200 apartment units.
Okay. And you're familiar with the overlay district and the proposed development in general?
Yes.
Okay. And you just described the proposed development. Approximately how far is 508 Heritage Oak Drive from the Prickett Preserve property?
It is 0.95 miles as the crow flies.
Okay. And if you could describe for the board, and if you want to use what has been marked as Exhibit A-10,
if you could describe for the board your thoughts on impact to traffic as a result of this proposed development.
Certainly. Thoughts are. The question is whether he's done a study and whether or not, based upon his study, he has a professional opinion.
Fair enough.
He's entitled to provide his thoughts on it, whether he submitted a formal report or not.
I'm not disputing that he didn't submit a formal report, but the issue isn't whether he has thoughts. The issue, he's a professional. He's a professional engineer. What we need is his opinion with a reasonable degree of scientific certainty based upon facts that he has determined, not what his general thoughts are.
He has reviewed the application. He has reviewed the traffic studies submitted by the developer, and he has analyzed those, and he has thoughts on those, and he is allowed to present his thoughts predicated on that.
His opinion. The township supports the objection offered by Mr. Harris. If Mr. Meth is being offered as an expert as to the impact of the alleged traffic increase or the negative traffic impact, he is to provide a professional opinion, not mere thoughts.
Then we could rephrase the question. Gordon, have you reviewed the traffic analysis that was prepared by McMahon and Associates for this proposed development?
Yes, I have.
Okay. Do you have a professional opinion as to how the traffic will be impacted around the area of 508 Heritage Oak Drive?
Yes, I do. I have opinions about the changes in traffic patterns as a result of the proposed development based on the study I reviewed, as well as reviewing information from Google Maps in combination with that.
Well, I object to his use of Google Maps. If he'd done traffic counts and done normal traffic study elements, that's one thing. But, relying on Google Maps is not what responsible traffic engineers rely on. I probably had and cross-examined, 100 traffic engineers. I have to admit that this is the first time anybody's tried to pawn off Google Maps as scientific data.
The applicant has presented information in its traffic study, and he has analyzed that. And it's not a question of pawning off, which is a very inappropriate term. It's a question of the applicant, Gordon Meth, is willing to offer a professional opinion.
All right. Let him offer his opinion.
He could testify as to whether Google Maps is something you would regularly use in determining or coming to a professional opinion.
As opposed
and then maybe that alleviates the objection.
Yeah. He is certainly entitled to offer his professional opinion. And it should also be noted, obviously, any traffic study done in the last 9 months would be subject to questions anyway in light of what has been going on in the world over the last 9 months.
Well, I don't mind him offering his opinion. Offering his opinion without his own traffic study is no different than a neighbor offered his opinion on traffic. But I'm okay. He's got qualifications. But I like to hear his opinion. But I have to say, without his actual traffic study, it really doesn't mean a lot to me. That's just to me. But go ahead, give his opinion.
And I'll just address one thing before he provides his opinion. It's certainly very different than a neighbor. Here's somebody with professional qualifications, which is different from Joe, your next door neighbor, who's an insurance salesman. So yeah, there is a tremendous distinction of professional opinion versus a lay opinion. Whether he's done his own traffic study doesn't necessarily negate the opinion. And moreover, the opinion And moreover, any traffic study done in the last 9 months, I'm not sure how valid that would be.
Well, I mean, I don't have a problem with him giving his opinion, but I do have a problem with him not doing an actual traffic study on it. But I'm okay with his opinion. I got no problem.
Hey, Tony, I just want to chime in here that I still have an issue. I don't understand how somebody that lives a mile away from here, across 95, has any standing at all. I mean, I can understand if they were on the same road, you know, quarter mile down, but given the distance and the fact that there are several hundred homes in between there and 95, I just don't see the purpose of entertaining this.
I understand that, Mike.
They have, I mean, that's the point of the testimony, is to establish that. Whether they ultimately can is the determination that the board can make. But they have to, you know, have that opportunity.
Okay. Can we have Mr. Meth offer his professional opinion here?
Sure.
Okay. Hey guys. Quiet. So my the main issue from my perspective, from the perspective of 508 Heritage Oak Drive, is impacts on a Saturday from the proposed development. The proposed development, unlike uses that were previously approved for this area, generate a lot of weekend traffic. And towards that, I'm going to now share my screen, and one of the exhibits in question, it's going to be the third page of the of Exhibit A10.
That's not us.
Sorry, I can't tell if it's sharing. There we go. So what I have done is I have overlaid a map showing 508 Heritage Oak Drive and the project in question. I don't know. Can you see the mouse when I do this?
Mm-hmm. Yes.
Okay. And I've looked at where there are signalized intersections between the site and 508 Heritage Oak Drive. Now, there is one traffic signal that was studied within the study was Township Line Road and Stony Hill Road. There was also the intersection of Stony Hill Road and Yardley Langhorne Road intersection was also studied. Other intersections were not. Now these intersections, the four that I just showed that are on Stony Hill Road that go all the way to Keokuk, they're all within 1 mile of the study area. Now, industry publications advise that for shopping centers above 100,000, you look at all signalized intersections within 1 mile of the study area. That's publication within the recommended practice of the Institute of Transportation Engineers for traffic impact analysis that is referred to in publication 282 of the Pennsylvania Department of Transportation when determining a study area. What I will say also on a Saturday is, even though the intersection of Township Line Road and Stony Hill Road and Yardley Langhorne Road were counted at the exact same day at the same time in June 1st, 2019, there's about a 300 vehicle discrepancy between the two counts. The traffic at this end is about double that. So that to me means that I think that count should be looked at again. The other information that's on this map, I've put bar charts up. These bar charts, and I think I can zoom, I wonder if I can zoom in. Probably if I pull out of the PowerPoint, I can zoom in a bit.
Oh, there you go. That's better. Oh, yeah.
Oh, that wasn't good. I moved all the images, and there it is. So the increases in traffic of this road, the first number, the 733, that's the existing traffic on this road. The 168 is traffic from other developments in the area. There's about 8 developments that were looked at for which they had not been built at the time the traffic counts were conducted. And then 117 is the amount of traffic from this site. About 15% of the new traffic from this site was assumed to be following Stony Hill Road in this direction. So we're talking about a 15% increase in traffic. Once you get past Yardley Langhorne Road, and between Yardley Langhorne Road and Heacock Road on Stony Hill Road, the increases in traffic are you go from 567 vehicles for existing traffic. You have 122 from proposed new developments and 79 for this proposed development, for the development question. Now, all of these numbers came from the McMahon traffic study, okay, and the counts they conducted and the analysis they performed. Within the map that's underneath it, one of the things that Google Maps does provide, and I only use it just as a reference just to get a sense of what travel times are like in this area, it color codes typical conditions. And these are the conditions typical to a Saturday at 12:30 based on Google Earth. Now, one of the advantages of the Google data that's here, and it is becoming much more commonplace to use, shall we say, what's generally known as big data to support traffic studies and analysis, because when you take account on one individual day and base all your opinions on that, you don't know what happened on that day. So it helps to get other data sources to double check it. Now, interestingly enough, what you see is that the travel time is shown as being slow on a typical Saturday along this area. Now, I will also say that the traffic study did not study anything past the Yardley Langhorne Road and Stony Hill Road intersection. It did analyze Township Line Road and Yardley Langhorne Road intersection at these two intersections at the request of the engineer for the township. So the key is, and why this matters, is that between the new developments that aren't built yet and the proposed development, you have an almost 40% increase in traffic. We're 35 to 40% increase in traffic on this roadway.
PowerPoint.
Gordon? Yeah.
I'm sorry?
We lost the screen for a second, Gordon.
Okay, I'm sorry, but
Can he repeat what he just said about, I didn't catch that.
Along Stony Hill Road, between the developments that are not built yet, the existing, the proposed, the unbuilt but approved developments, and the proposed project, there will be a 35 to 40% increase in traffic on a Saturday based on these projections. When there are intersections that may be impacted, and what happens is when an intersection starts to approach capacity, the delay starts increasing exponentially. And the reason why that happens is once not all the cars that arrive at an intersection can get through during a given period of time, then what happens, you have to join the back of the line, and the line grows, and then people have to get through it in queuing. So the reason why the 508 Heritage Oak Drive is specifically impacted by this project is the fact that this project is going to increase traffic on the roads that provide access to that property by 15% in themselves. And the overall increase in traffic from that development and other developments is going to be approximately 35 to 40%. And the evidence already shows that these intersections are approaching capacity.
Mr. Meth, what was the intersection grade at Yardley Langhorne?
The intersection analyzed overall operated along.
Need your screen back.
Sorry. Do you want, let me, put my screen back? Is that?
It's just timed out. It's fine.
If you're using it.
Well, I can stop sharing. That may help.
Okay.
I think I'm done with what I wanted to show.
All right.
So stop share. There it is. Okay.
So what was the existing level of the intersection?
The existing levels of the intersection, well, first of all, the only intersection analyzed in that area I pointed to was Stony Hill Road and Yardley Langhorne Road. However, as I stated earlier, the traffic, all of a sudden, the 733 vehicles that were on the road at one end of that block, meaning by Township Line Road, were suddenly 433 in the traffic study. So I have a big question mark in my mind about the veracity of that count.
I understand. Could you answer my question, please?
The study had, I believe, levels of service B and C overall, but
what did it drop down to?
Level service D.
Say that again.
Certain movements operated at what's known as level service D.
Okay, and after the development improvements, what did they drop to?
Well, the overall intersection was still at a level service C, but one of the approaches was at level service E in the future. That would be the one heading, I guess, depends on, everything's at about a 45-degree angle, but heading towards the development along Stony Hill Road.
What's the future?
That was the future built analysis.
And the future built analysis included that development plus other developments in the area, correct?
It included that. However, if there was a problem with the baseline count, that analysis may not be correct.
Did you determine if the baseline counts were appropriate in your own study or traffic counts?
Okay, the study I did was a thorough review of the one prepared by McMahon.
Okay.
They included within that the actual traffic counts.
Understood.
And they counted traffic on the same day. And they have a large discrepancy between the two intersections, which the problem with knowing the volume at two intersections, it doesn't really tell you which one's right or wrong.
Well, it has to tell you the amount of cars counted. I'm sure they had some kind of method they were counting, and I don't see your evidence of how you see that's wrong. I'm waiting. I'm still waiting.
Okay, I'll give you a more specific answer.
Can I ask a quick thing which might get things moving? Is the allegation then that if the study is wrong, the impact would be more substantial to the applicants, or is it just an attack on the study itself?
It would be, it impacts the applicants because if that intersection operates at far worse levels of service than one would assume, any increase in traffic further degrades that intersection.
I don't think you answered this question though. Are you attacking the study as it's being actually inaccurate and it has no worth?
I am saying that one intersection, I would not trust the results of it right now based on the information I've seen. So I guess I don't, because of the fact that the volume is so much lower than at that one intersection versus Township Line Road, then I question whether the level of service is really what they said, really what the study calculated. I'm not saying they calculated anything wrong. I'm saying that the base count they used may have somehow been inaccurate.
Well, I haven't objected so far because sometimes we waste more time with objections than just let the testimony continue. But other than attacking the study, there has been nothing in this testimony that has shown that the impact, whether the study was right, wrong, or indifferent, is any different on 508 Heritage Oak Drive than it is on 510 Heritage Oak Drive, 512 Heritage Oak Drive. If the traffic at that intersection it doubles, it's the same impact that everybody in the area shares. And in order to have standing, you have to have an impact that's different than everybody else. So this testimony is absolutely irrelevant.
And I would disagree with that. You don't need necessarily discernible from every other human being in Lower Makefield. What you need is discernible from just the overall population. So somebody on the opposite side of town may not have this issue. That doesn't mean that somebody at 508 Heritage Oak Drive cannot have the same issue or the same concerns as somebody at 506 Heritage Oak Drive.
He may have an issue, but it doesn't mean that he has to stay. I mean, I still find this odd that he didn't do his own study. And basically he's saying that study that we saw before was worthless. And I'm trying to find out how he feels that way.
And I would join in Mr. Harris's objection in that the evidence or the testimony presented so far shows that this alleged inaccurate count possibly would increase traffic along the routes as shown that would affect all of the residents along that area, and therefore does not show some discernible adverse effect to Mr. Borda or the other applicants other than an abstract interest that would affect all citizens as set forth in the case law.
And Gordon, then maybe if you could just flesh out a little bit further about the impact in that immediate area or that immediate development of 508 Heritage.
Within this area, within the area of 508 Heritage, you have a road that is substantially impacted by the proposed development. It has 15% of the site traffic coming on it. That would be Stony Hill Road. That one road is one of the major gateways to this development. And that road happens to have several very closely spaced intersections that most of them do not have left turn arrows. A lot of the approaches don't have left turn lanes. The basic information available about travel times in this area on a Saturday show that area is that people can expect it to go slow, that you can't get through it very quickly. That is a data point that shows that there are existing traffic issues or delay. It could be because of the traffic signals and the timing. It could be because of capacity.
So there are existing traffic issues as we speak today.
Yes, we all know it's a lot of traffic in the area, but he keeps avoiding the part, at least to me he has, the improved possibility to improve traffic lanes and light changes that he doesn't seem to bring up. And I would think that they would be addressed with this project, because I heard that. Now, I disagree that most people will be coming down that road to go to that project when there's 95 and 322 right there. So that was part of that study where they showed a lot of that traffic, especially truck traffic, would come from 322 and not come down Stony Hill Road. I mean, I live right there, so I see it. I know it's crowded. We already know it's crowded there. So I have to wonder if he really feels that that's where all the traffic is going to come from to go to this project.
Well, first of all, if I can answer your question, Mr. Chairman, I'll take them one at a time. I'll answer your last question first. Mm-hmm. This site, this is less than a mile from the proposed use. And the applicant, when they did their analysis, assumed 15% of the traffic for this site was coming up Stony Hill Road. All right, coming to and from Stony Hill Road, meaning the local area, meaning it does not get on and off 295. And where you started about the number of lanes improved and the number of traffic improvements that come with this, all of the improvements proposed as part of this development save some signalization changes Township Line Road and Stony Hill Road are up by the bypass and the interchange for 295. That's where all the improvements are. They're not on Stony Hill Road in near 508 Heritage Oak Drive. There are no improvements proposed whatsoever.
So far, you're all right. I'd go with that. I do remember the study was concentrating on 322 and 95. I do remember that was most of it.
So Gordon, taking that a step further, the improvements that are proposed aren't designed for the smaller local roads, correct?
They are not. They stop at the signal that is closest to the site in terms of the traffic study is projecting 25% of the traffic going down Township Line Road and 15% of it going to and from Stony Hill Road. The only improvement they're doing there is adding an overlap right turn arrow effectively to give people more green time to make a right turn from Stony Hill Road up the northern part of Stony Hill Road into the development. That's the only improvement proposed in the direction for which nearly half of the site traffic is projected to come to be directed towards.
And by not addressing traffic improvements in the area we're discussing, what does that mean for someone who lives at 508 Heritage Oak Drive?
That means that anyone who lives at 508 Heritage Drive will feel the negative consequences of this project without the benefit of the improvement dollars that would come with any development under your Act 209 transportation improvement fee, because all the improvements are being spent over by the interchange and the bypass, not in this direction for this project.
So he will feel an increase in traffic as a result of this development.
Well, yes, the roads in question will get surcharged by extra traffic, and not a small increase. A 15% increase in traffic is fairly substantial.
On a Saturday, as you mentioned.
On a Saturday, yes.
Mm-hmm. Well, there's no question there's increased traffic. We all understand that. We do. We really wish you had actually done your own study. And I got it. I got your opinion. Your qualifications sound excellent. And I understand that. But I travel. I mean, I don't know if everybody's agreeing with you on that. You said 50% of the traffic that I proposed project is going to go down Stony Hill Road?
No, I said 15. 1-5.
I heard you say 50. All right. I think that was in the study, 15%. Maybe.
Correct.
I don't have that in front of me, so I can't ascertain. Anybody on the board remember that? I don't remember.
I believe what you might be referring to, Mr. Chairman, is I said that between Township Line Road, where 25% of the traffic is heading down, and this direction, nearly half of the traffic goes this way.
That's what you said, yes.
We're just going to get into that. Yeah, we're going to get back to see it.
Is there any testimony about the other properties? Because you've just focused on the one at 508 Heritage Oak.
I can testify similarly for 1776 Cypress. What is it? The exact address? Cypress Way, if you wish.
Sure, if you could, Gordon, please.
How far away is that, Gordon?
That is just over 2 miles.
2 miles. Go ahead.
And ordinarily, I would say that, okay, you're starting to get outside the range that you keep looking at traffic impacts. However, there is one intersection that.
And Gordon, just what are you referring to, please?
I'm sorry. I just put up on the screen Exhibit A10, page 5 of it, the last page of it. So what I've shown on the map, I think I have to move the screen up a little bit to show the site. You have the proposed, yes, you have the proposed projects here at the top. And then you have Township Line Road, as it traverses down to 1776 Cypress Way. And at one point, the road becomes Big Oak Road.
Mm-hmm.
Now, the one issue on this roadway is that you have a stop sign for Township Line Road in the southbound direction by a rail grade crossing. You also have a stop sign on Big Oak Road, but you do not have a northbound stop sign.
That's correct.
So the stop signs are are not designed to handle the kind of traffic that are being proposed as part of this development. And I'll zoom in right now on the bar chart that shows the increase in traffic in this area. So what you have is on a Saturday, you have 553 vehicles on the section of Township Line Road, south of Yardley Langhorne Road. The other developments that have not been built yet, but have been approved, count for 48 extra vehicles. 78 are proposed or projected for this project to be using this section of road. So you've got similar increases in traffic that we were talking about on Stony Hill Road.
Timed out.
I'll give me a second. I'm just going to find a specific number, then I'll flip it back. So the site traffic is about a 15% increase. The proposed site has about a 15% increase over existing here as well. The only thing is a stop sign is not designed to handle this amount of traffic. And I mean, normally, in my experience, anytime you have more than 600 vehicles on a stop controlled approach, it's not going to work very well because people have to stop, watch for a gap, then proceed. And there's been no study of this intersection. And and you can even see the orange line where people approach this stop sign in Google Maps for any time of day. That the amount of traffic on Township Line Road is just not consistent and compatible with the traffic control that's on it. And that's really how 1776 Cypress Way and any other homes near there is disproportionately impacted by this project. If they have, to the extent that they have to rely on that for access. I'll stop my screen share now.
Well, I know the study probably wasn't done because it's 2 miles or more away. I'm sure they got to stop somewhere. And I don't doubt what you're saying, but where do you stop? And I understand your increase on a Saturday. I got that, but I'm still trying to see where you're standing wise with this.
I believe you stop at Township Line Road southbound at Big Oak Road.
Because why?
Because there's a stop sign.
Oh, that's the only criteria? Okay.
No, Gordon. I think he's asking at what point do you stop from a traffic analysis?
Okay, I'm sorry, I misunderstood the question.
Not physically stop the drive. It's, at what point, I think
how far away do we go?
I think what the chairman's asking is where, you're saying that there wasn't a traffic analysis done in certain areas.
Right. What are the parameters of the traffic study?
Well, what I will tell you is the guidelines tell you, the guidelines, which are the recommended practice for conducting a traffic impact study by the Institute of Transportation Engineers, which publication 282 of PennDOT, which sets the rules for doing a traffic study, specifically reference, says that you look at for a shopping center of more than 100,000 square feet, you look within a 2-mile radius of the project. And the stop sign in question that we're talking about is less than 2 miles from the site. It was between 1 and 2 miles from the site. And it tells you should be looking at signalized intersections within 2 miles of the site and any major stop controlled intersections within 1 mile. But I would tell you that the Township Line Road at every other intersection is signalized. And because this is the main roadway, that I would think that intersection should be a study location.
Maybe they would.
Reason. I mean, a quarter of the traffic is heading in that general direction. A portion of it turns off at Yardley Langhorne Road, but a portion of it continues, and it goes right to that stop sign.
I'm curious to understand why PennDOT didn't come up with these same things. We saw that, and they didn't seem to come up with. They did have a couple recommendations. They did, but it didn't seem to be as much as you're saying. I'm not saying you're wrong or they're right, but they didn't seem to indicate that.
Well, what I will say is my recollection of the testimony from August was that there's been an initial meeting with PennDOT, but they have not accepted this yet. There were
they did have a traffic study with PennDOT in there. We did McMahon was it with McMahon? They did have a traffic study.
They had a traffic study.
PennDOT was involved with that traffic study.
Correct. They testified that they had a meeting with PennDOT, but that PennDOT has not performed a final ruling yet. I could be wrong, but that's my recollection of the testimony. I do know that your township engineer or the traffic engineer for the township, when he was reviewing it, had specifically requested the intersections of Township Line Road and Yardley Langhorne Road be looked at, and Stony Hill Road and Yardley Langhorne Road be looked at, even though it wasn't in the initial submission to PennDOT. And he also suggested that an improvement be developed that solves the traffic problem at the bypass and Stony Hill Road, because PennDOT, under their regulations, would not really require a full improvement of that intersection, only a partial improvement.
So since August, they accepted it. Since August, when we talked about it.
Are we up to cross-examination?
Is there any testimony about the third property?
No, I'm not prepared to give that.
Okay.
All right. Well, and we could have. I'm sorry, Mr. Harris, is that you?
That's me.
Did you want to cross-examine this? Or
Hold on one second. Mr. Goldberg, do you have any further questions for Gordon Meth on the traffic impact as it relates to the subject properties?
Not at this point, no.
Okay, so then, yeah, we could go for a cross.
Mr. Muth, the standards published by ITE for a traffic study, do they recognize the use of Google Maps for a traffic study that meets their standards, or do they require specific traffic counts?
First of all, the publication in question was published in 2010. It is being revised.
That's not my question. My question is, maybe I'll ask it a different way. In fact, the standards of ITE require traffic counts for a traffic study that would be submitted to the municipality or a state agency, correct?
It would require traffic counts because it requires analysis of intersections. There's not enough information from Google to perform traffic analysis at specific locations and perform level of service calculations.
Yeah.
The answer is no, it does not specifically mention Google.
And if I understand your testimony is that generally there will be an increase in traffic as a result of this development, correct?
I don't know if the word generally is appropriate. There is a specific increase in traffic because of this project.
Okay. And that specific increase in traffic as a result of this project is going to be felt and experienced by everybody who uses that road network, isn't it?
It's not going to be felt the same way in the same areas. It will have different impacts on different roads based on where the traffic is going and the capacity of that road, available capacity of that road. So no, it is not a generic, it's not going to be felt the same way for everyone on every road.
So everyone that uses the intersection at Stony Hill Road and Haycock Road will suffer exactly the same impact, won't it? Won't they?
No, it depends on what direction they're moving. Every single intersection, every movement operates slightly differently.
So everybody going in one direction towards that intersection is going to experience exactly the same delay that everybody else is going to experience, no matter where in the township they come from, correct?
For that movement, yes, everyone on the one movement will experience the same level of delay.
And your testimony is limited to the impact of cars approaching the intersection and using Stony Hill Road and Haycock Road, for example. You have not, you have no opinion as to whether there will or will not be an impact, for example, on Heritage Oak Drive.
I do not have an opinion if that there will be a specific impact to Heritage Oak Drive per se, no.
And you don't have a specific opinion as to whether there'll be an impact on Cypress Way, do you?
Not Cypress Way itself, only when the traffic from Cypress Way leaves their development and goes to the arterial and collector road system. That's
and everyone, I'm sorry, everyone that comes out of Cypress Way and heads into that road system will suffer exactly the same increase, the results of the increase in traffic, correct?
Yes.
And everybody that comes out of Heritage Oak Drive onto the road system will suffer exactly the same increase in traffic, won't they?
More or less, yes.
That's all I have. No, I'll ask you one other question. You talked about the traffic impact study and the fact that there's a difference in traffic impact as a result of the pandemic, and I think that all of us acknowledge that. But in fact, the traffic study prepared by McMahon was all the traffic counts were prior to the pandemic, correct?
That prior to the U.S. cases of the pandemic, yes.
Well, that was the one that affected traffic and the reduction in traffic, not China, correct?
Correct.
And have you checked to determine whether in the time period between August and today, whether or not PennDOT has in fact accepted the McMahon study?
I have not.
Well, I can't testify, so that'll be all the questions that I ask.
Well, at this point, we're getting to our 10 o'clock curfew. Obviously, this would matter, probably should be continued.
Well, can we have Barbara cross-examine and then?
If you want, if we feel that's okay, I just did not want to not bring this up. That's all.
Yeah, Barbara, do you have any cross?
I do, if I may.
Absolutely. Go ahead.
Thank you. Mr. Smith, Muth or Matt? Muth.
Math.
Matt, I'm sorry. You did indicate in testimony that there would be a 35 to 40% increase of traffic from the property down along Stony Hill Road. Is that correct?
I testified to be a 35 to 40% increase in traffic from existing levels through a combination of the other approved and non-built developments plus the development question, yes.
So your estimate is based upon projected future development other than the proposed development at this property?
I believe I gave both numbers. I said that the overall increase in traffic was 35 to 40% along Stony Hill Road, but that the specific increase from this development was about 15% above existing traffic levels.
Okay. And the traffic that runs along Stony Hill Road would affect anybody that is driving along that direction on Stony Hill Road?
Depending on where they do their turns, they could be impacted differently. But
if traffic exists along Stony Hill Road and you're on Stony Hill Road going in the same direction as traffic, you will be impacted.
You'll be impacted, but the way traffic works in a situation like this is it's not the road itself that's the issue, it's the intersections that it meets. So your delay experience will depend on which approach you're coming from, whether you're making a left turn or a through movement or whatnot. So there's different impacts depending on which way you're turning or moving at the intersections.
Now, you also indicated that you looked at the traffic counts as contained in McMahon's study, correct?
Correct.
And you said you believe those base counts may be wrong.
Yes, specifically.
Did you perform independent, separate base counts?
No, they performed counts at two different intersections. If you look at the traffic from one intersection, you can total the traffic on Stony Hill Road by Township Line Road. All right, that's one side of it. And that totaled 733 vehicles on a Saturday. If you count the traffic on Stony Hill Road at Yardley Langhorne Road, you will count only 431 vehicles on the Saturday peak. That's the discrepancy. That's the difference. And there are driveways in between, but I didn't see anything that would have accounted for about a 300 vehicle an hour change between those intersections.
Now, you had access to this traffic study prior to the hearings held before the Board of Supervisors. Isn't that correct?
That is correct.
And you had the opportunity to review that traffic study at that time. Isn't that correct?
I did.
And did you at that time address that the base counts were wrong?
I hadn't noticed by that point until I did a detailed looking on the impacts on Stony Hill Road.
But you had
No,
full
I did not.
opportunity to provide this opinion at the time of the Board of Supervisors hearing, but for the lack of your more detailed review of the traffic study. Correct?
I guess that's correct.
Okay. Now, you said that that the address of, give me 1 second, 508 Heritage Oak Drive will feel negative effects under any development. Is that correct?
It would be potentially impacted by any development that generates traffic, yes.
So, and that would also affect anybody else within that vicinity of Heritage Oak Drive, correct?
It wouldn't necessarily impact them to the same level.
Okay.
It depends on what the development is and what its distribution patterns are.
But it would affect all of the residents within the development where Heritage Oak Drive is located.
Yes, it would.
Okay. And it would also impact whatever other developments are in the same vicinity as Heritage Oak Drive, correct?
Yes, it would.
Okay. And as to 1776 Cypress Way, that you said is 2 miles away from the proposed subject, the property that's under the overlay district, correct?
Yes, I believe the exact measurement is 2.19 miles.
Okay. And your testimony said about a quarter of the increased traffic would be headed down Township Line Road towards 1776 Cypress Way, right?
Well, yes, but it does, a fair amount of the traffic does turn on Yardley Langhorne Road. So it doesn't all go all the way down there.
I thought you said under direct examination that about the increase in traffic from this development, about a quarter of it would travel towards the Cypress Way, which would negatively impact Cypress Way.
Well, to the extent that Township Line Road is in the direction of Cypress Way, yes, it's 25% heading that direction.
How many other residential developments are along Township Line Road between the subject property and 1776 Cypress Way?
I have not done a count of them.
Okay. There are more than one other residential development, isn't that correct?
I believe so.
There's some apartment complexes along that vicinity, isn't that correct?
I believe I've seen them, yes.
And there's new development that has been recently constructed, which is residential, right in the general area, Big Oak Road, as well as what you have designated, I believe, as Lincoln Highway on your map.
Is it Lincoln Highway?
You have it designated as Route 1.
Well, Google has it represented as Route 1.
And
But
so
yes.
there's additional development that's there. So all those developments that exist along Township Line Road will have negative effects, won't they, from this increased traffic?
Well, any traffic using Township Line Road would be potentially negatively impacted, yes.
Okay. So how is it, strike that. And where is the third property located for the third applicant that's subject to these proceedings?
It's to the north and east of 295 and bypass.
And that address would be what? Do you know?
Give me 1 second. It's 1412 Heather Circle.
And how far is that property from the subject property?
I believe it is just over a mile. I don't have an exact measurement available right now, though.
So based on the testimony that you provided relative to the amount of traffic that would negatively affect the property on Cypress Way, as well as the property on Heritage Oak Drive, is it fair to say that there would not be as much of an impact upon the Heather Circle property by the increase in traffic?
That was my conclusion, yes. There would not be.
I have nothing further.
All right, obviously we got more to talk about. It is getting late. What are we going to do here? Obviously we need a continuance.
Well, I would ask the board to take under advisement that based upon the testimony provided by Mr. Meth, that his testimony, while it does acknowledge an increase in traffic, that increase in traffic will negatively affect the same general citizens rate just as much as it would the three applicants. And as a result, these three applicants do not have the standing under the current case law within which to move forward with this challenge. And I think it should be dismissed.
Adam, upon what Barbara just said, and I'm not saying I actually understand it, do we need to hear public testimony before we make a decision on that? What do we do?
Well, I don't think, and that's why I wanted to chime in, that Mr. Goldberg may have additional testimony that he was planning to introduce on the standing issue.
Mm-hmm.
That is correct, Adam.
And who else would be testifying strictly on the standing issue?
There would be an economist.
Okay. Would there be testimony from any of the applicants themselves?
The answer is yes.
And can Mr. Goldberg provide an offer of proof as to the testimony of the economist?
Sure. The two remaining people who would testify would be one of the applicants, Larry Borda, as well as the economist. And in terms of the offer of proof as the economist, what the economist will testify is that what is being proposed by the developer is not realistic. The 200 apartments will not provide the rents that are alleged by the developer. The apartments will end up having lesser rents. It will be a different group of people there. It is not viable as they are proposing. As a result of this, there will be a diminution of property values for people in general area, such as the one at Heritage Oak. Obviously, it is not unique to Heritage Oak, 508 Heritage Oak Drive, in terms of that the person at 506 Heritage Oak Drive will also feel the same impact. However, it doesn't impact every single person in the township the same. And by virtue of the location of 508 Heritage Oak Drive, it is very realistic to believe that there will be a decrease in property value.
And I would object to the testimony of the economist as one, that testimony is substantially the same as what was provided before the Board of Supervisors. And two, absent a study, a speculation as to what may be realistic and may result in a diminution of property values does not meet the requirements in order to be an aggrieved person to challenge the adoption of a zoning ordinance.
And I'm not sure what the fact that there's testimony before the Board of Supervisors has to do with this hearing, but I'm still confused by that. But additionally, the testimony, I disagree with the objection, as the testimony will show that based on their professional opinion as to what will most likely happen, there will be a decrease in property values.
And the problem with the opinion is that what he's basically said is that if you're a mile away from this property, you're going to suffer a cumulative negative impact of 1.8% of the value of the property. So every property, his report basically says every property that's a mile away is going to have a 1.8% diminution of value. That just isn't testimony that provides standing. I mean, I read the report. It again is a generalized impact on all residents within the township.
And I disagree that's necessarily every single house within that. I think some are different, but I will disagree with that point.
Can I bring something up? That study is only relating to 508 Heritage Oak Drive, correct?
Yes.
Okay. And Larry Borda lives at that address. However, there's two other properties. And so the economist then would not be testifying about the 1412 Heather Circle. Mr. Meth did not testify about the 1412 Heather Circle. So is there any testimony or any other evidence as it relates to 1412 Heather Circle owned by Brian McNamara?
Not specifically to that address.
So is there any, so there's no evidence for his standing then that's being presented today or at a continued hearing?
There is nothing unique to Brian, correct?
Yeah.
So the economist then would just be talking. So you would have the economist supporting standing for 508 along with Mr. Meth. Mr. Meth supporting it for the 1776 address. And then would there be any additional evidence or testimony about Mr. Dobson at 1776 Cypress Way?
No, the only other person to testify would be Mr. Board in addition to the economist.
Okay. If that is the case, I would say the board could make a determination if they wanted to now on the Dobson and McNamara standing, and then at a continued hearing, you could make a determination after additional evidence or testimony about Mr. Borda. But if there's no additional evidence about Mr. McNamara or Mr. Dobson, then a determination, it seems, could be made now. However, we would then have to allow public comment and all of that. So I don't know that it's feasible since it's 10:15 at the moment.
Yes, I agree with you, Adam.
So it might make sense, but I just want to clear that up so that way at a continued hearing, we know what we are and are not.
That's good. That's good. I just feel that, it's getting late, and I do know there's public comment. I do agree with that. But I'm just a little uncertain about making a decision now. I'll take some my colleagues' opinions if they want to chime in here. I appreciate it.
As to making a determination, or to push
standing on those two properties, right, Adam? That's
You
what
have to hear more.
Well, again, if you're going to make that determination, then you're going to have to entertain public comment.
Well, no, then we
first,
can't.
And so you can't actually do that. So if you want to actually,
let's continue this.
Continue it. We don't have a choice. We got to.
Yeah. I mean, our next meeting would be, I believe, January 5th is the first Tuesday of January. I don't know if there's anything else on the agenda, but we could try to.
We should probably try to make it all this.
Yeah, that may not be a bad idea. Jim, do we have anything else on the agenda? Do you know for the 5th?
Yes, if I may, I'm involved in that hearing for the Mill Road property.
Is that correct?
That got carried to January 5th. That was the one with the redevelopment of the property where there's that historic stone house with additions. That got carried to
Yeah, I think that's
January
Ken Koretsky Jr., if I'm not mistaken.
Yes.
Okay. Anything else, Jim?
No.
Okay, so that shouldn't be too bad then.
Okay. Keep it that way. No additional appeals on that day.
Correct.
All right.
Okay. All right. So then, due to the time, then a continuance would be in order.
I think so.
For the next available hearing on January 5th, so that the hearing can continue on the issue of standing after all relevant evidence and testimony is offered at that point. The board can make a determination as to whether they're standing. If there's not, it would be over. If there is, we could proceed to a full hearing on the merits.
I do want to ask you, Adam, on the public.
Question here. Would we move from standing to jurisdiction then, correct? And then to a full hearing?
Yes.
Jurisdiction.
I would ask for the jurisdictional issue too, in light of the fact that there's a common pleas pool complaint that's been filed as well by these three individuals that substantially raises the same challenges to the ordinance.
Is there anything odd about that? It sounds like it, but I just want to know if that was
it's odd.
Appropriate.
Well, there's a in the MPC, there is the language that you can only make one challenge at a time.
I'm sorry, Adam, what were you done? I was just going to, I didn't mean to interrupt. I wasn't sure if you were finished or not.
No, you can speak.
Okay. The answer to the question is, it's a hybrid situation where you have procedural matters and also substantive matters. Under the MPC, procedural matters are meant to go directly to Doylestown, the Court of Common Pleas. Substantive matters before the Zoning Hearing Board. This is a weird situation, and as a result, to kind of be belt and suspenders and out of an abundance of caution, we filed the procedural matter in Bucks County Court of Common Pleas, but also added the substantive claim in case there became an issue here, and did the converse here, where we had to file the substantive challenge here, but also just included the procedural issue, again, out of an abundance of caution.
But if there's how can the common pleas court decide on that without knowing if they have standing?
But we've raised the standing issue in the common pleas court as well.
Okay. All right. Now, my next well, before you make the motion, I just want to ask one more question, Peter. Thank you. This public comment, is that going to be involved with this? How's that going to affect this issue we have with the standing?
Well, you can have public comment on that specific issue. If it got to a full hearing, you could then have public comment on, again, about the substance of the application itself. If there's public comment, and again, I'll reiterate this next meeting just so the public is aware. If there's public comment specifically on the issue of standing, can have them speak to that, but we wouldn't want comment on the underlying issues if we haven't ourselves entertained that yet.
That's what I want to make sure is clear. That's good. All right. Peter?
Make a motion to continue appeal number 201881 to January 5th, 2021.
Anybody a second?
Second.
Any discussion? All those in favor? Aye.
Aye.
And is anybody opposed? Ayes have it. Continue to January 5th. Thank you very much, guys. All you other guys as well. Gordon, I don't remember all the names. Thank you very much.
Thank you.
Thank you, and have a happy holiday.
Thank you, Mr.
Have a
Harris.
great holidays, guys.
Okay.
Happy holidays.
Happy
Bye.
All right. We'll
see
see you
everyone in
guys.
2021.
Let's get should we have a motion to adjourn?
Motion to adjourn.
Second? Second. All those in favor, say aye.
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 Okay, we're adjourned.
Night.
Thank you.